All right, welcome back. And we will proceed with the next case on the docket, HITCHNER versus SUNTRUST Bank. Let me get the clock reset for just a second here, if you'll bear with me.
Yes, Your Honor, I'd like to reserve 3 minutes for...
3 minutes?
3 minutes.
Okay, you're all set to go.
Yes, may it please the Court. I'm Michael Boswell.
You can speak up just a little bit.
Okay. I appeared before the Court, different panel of the Court last Thursday, and since then I have developed a rip-roaring head cold, and so...
Okay.
I'm with you on that. I'm working at my best, but anyway, I'm with Advocates Legal Clinic in Deltona, and we are here representing the appellant. Your Honors, within our briefs, we basically have argued 3 points before the Court. The first being that at the trial level that we were in, that the facts that were presented before the trial level court, that we should have had an evidentiary hearing.
Why did you need an evidentiary hearing?
Because
what were the disputed facts?
The disputed facts were that the process server made no attempt.
But they agreed to that, didn't they?
They agreed to that.
In other words, they said, look, we're not disputing the fact.
Well,
why would you need an evidentiary hearing if the other side says take the facts like you say they are?
Well, did they voluntarily agree to those facts?
Well, they just said that they're not disputed.
Well, the trial court said you're not going to contest those facts, all right?
Okay.
And to that, the trial level attorney said no.
There you go.
Right.
So the facts were as you wanted them to be.
The facts were as we wanted them to be.
So why did you need an evidentiary hearing?
Because then...
You want some other... Did you contest the facts? Or?
Well, the court, the trial level court, within the transcript on page 7, line 16 through 17, asked me, proffering, relative to the summons as to whether the process server had ever given him the summons, and I'm never able to answer that question. But if the facts were undisputed, right. In paragraph 6 of our complaint, we stated that that the process server never made any identification of himself.
Where does it say he has to?
The Florida statute 48.0355 says that on any document served within the state of Florida, that the person serving process shall place on a copy served the date and time of service, his or her identification number, and the initials for service of process. He has to identify...
Did you argue that below?
Our argument is that would be a disputed fact in
well, he either did or he didn't. But I mean, did you argue that was your rub before he didn't initial the thing?
We were the trial level judge basically cut us off as indicated within the transcript, but within the face of our verified motion to quash, we said he never identified himself, and that is broad enough to include...
Well, I mean, what you said was he never identified himself, said who he was, and never presented to your client a copy of the order that appointed him to be a process server.
Well, never identified himself as broad enough.
That seemed to be that was your issue below. You didn't say, well, he didn't comply with the statute by initially. You know, you never said, I mean, it appeared to me that your client actually got the document. I mean, the whole rub seemed to be was he didn't identify himself as being a processor. He wore plain clothes and whatever, and that was it. And you moved to quash based upon that, and that was undisputed, it seemed.
We moved to quash based upon the fact that he never identified himself, within our verified motion to quash, is broad enough to include that he never identified himself as specifically required under 48.
Well, does that statute say that you have to introduce yourself or identify yourself to the person as a process server, or does it just simply say you put your initials and number on the document?
It says that you put your initials and your number on the document.
No difference between the two?
There is a difference between the two, but that difference, it was unresolved at the trial level. At the trial level, we said he never identified himself.
No, and the statute says you put your initials and your number, but the statute doesn't say you introduce yourself or you say to the person that you're serving, I am a process server. The statute just requires the initials and the number.
Correct.
If the legislature wanted the introduction or wanted the oral part as a predicate to the service, they would put that in the statute, wouldn't they?
They would have, but what the process server placed on the document that he was attempting to serve my client was never addressed at an evidentiary hearing, and yet in our verified motion to quash, we said that he never identified himself, which without an evidentiary hearing.
Is your issue what he placed on the document, or is your issue that he didn't orally announce that I am a process server and introduce himself and make it known that I am a process server when he handed the document to them? What is your issue here?
Our issue is that he never made an identification of himself, and that issue should have required an evidentiary hearing at the point where there was an affidavit of service that was filed. My client filed a verified motion to quash that says he never identified himself and I was not properly served. That would have required an evidentiary hearing. That's in paragraph 6 of our verified motion to quash.
Your two issues on appeal, I'm looking at your brief, where the court erred as a matter of law when it denied the appellant's motion to quash without an evidentiary hearing. And then the court erred as a matter of law when it denied the appellant's motion to strike the notice for a non-evident. In other words, it all went to the hearing. And it seemed to me like the bank said, there's no disputed facts. We'll take them as you said. No one raised, I don't think, in the trial court about the signing of it. The whole rub was he didn't identify himself or give him you cited some case law, I think, or cases, not case law, in this circuit, which said, well, I think, some trial judge said, well, I think you ought to give him a copy of the order, but there's no legal requirement that I can see to do that. You're not saying that the processor was not properly, ordered by the court to be a processor, right? They were a disinterested person. They were over the age. In other words, you're not disputing that part.
We have made that argument for the first time within our reply brief, basically saying that it's our contention that under the petition of Stoll case, that for the court to be able to come in and to appoint an Ellisor, that the sheriff has to have requires a default or a disqualification of the sheriff or other officers so authorized. But the gravamen of our case was
1.070, doesn't that say that you can have an Ellisor appointed by the court as long as they're uninterested? And, that's what it was under, wasn't it?
That's what it was under, and interpreting that statute.
But your whole thrust seemed to be, look, Judge, you want us to find there was no evidentiary hearing, therefore, it's wrong. And I still can't see why.
Our contention is that we should have received an evidentiary hearing, but if they concede our facts, we should have won.
To present undisputed facts?
If they have adopted our facts and have said he never identified himself to the individuals.
They said that.
Okay. Then within the scope of he never identified himself to the individuals is that he did not place his initials on what he served and he did not put his ID number. We should have won then, based upon the requirements of the statute.
So if they adopt our argued that to the court, which you didn't.
And again, in my argument before the court, where on page 7, where I was asked about the actual summons, I was never given the opportunity to answer that question. And then whenever after we were asked after the bank's attorney indicated that they were not contesting my facts, then and the argument returned to me, we basically came in and are in the thrust of making the argument that service has not been proper, and the court cut me off, basically indicated that whenever addressing the court, I should not address the court in the second person, but should address the court in the third person, and then made its ruling. So I was not afforded the opportunity to be able to come in and to be able to make the opportunity for the argument under the 48-031. And so, but if the lower court came in and said, okay, they have adopted your facts, he never identified himself, then the court should have ruled for us, because within the scope of never having identified himself is a requirement under the statute that he was to place his initials and his ID on.
Did you ever mention that at all in your initial brief?
In our initial brief?
Yeah.
No.
You never mentioned that, did you?
No, we argued it in our reply brief, because during the interim is whenever the 4th DCA came in and made the decision in the Vidal case that said that when the legislature required these elements, that these elements must be succinctly followed, and that it is not within the court's discretion to try and determine what the legislature meant and why it meant to have these elements, but if these elements were not succinctly followed, that then the service was then not perfected and was not good service. And so in this matter, we believed that we were entitled to an evidentiary hearing. We argued for an evidentiary hearing. We moved to strike to be able to obtain an evidentiary hearing. We were denied that. Whenever the other side came in and then said, agreed with the judge and said, okay, yes, we're going to adopt those facts, then if the facts were not in dispute relative to the non-identification by the process server, then equally the process server had not fulfilled the statutory requirements of placing the initials on the documents that were served and their ID, and in that instance, then the court should have ruled for us. We believe that, and we are asking this court to be able to follow the 4th DCA decision in the Vidal case and determine that the 4 elements of appropriate service required on the documents that the process server serves.
Did Vidal ever make the argument below, or did he make it for the first time on appeal in the Vidal case?
I don't believe that the facts in the Vidal case identify that. But again, in our case, it was our argument that the process server never identified himself. We were at the trial level court, we were not given the opportunity to be able to expand upon what that meant. We were not given an evidentiary hearing, and then whenever the bank agreed with the facts so that there were no facts in dispute, then they would have agreed that the process server did not put his initials on what was served and did not place his ID number on what was served. And so under those facts, as applied under the statute and as applied by Vidal, the court then should have ruled for us. And so it's our argument that the court misapplied the statute and that this court then, based upon the misapplication of the statute, this court should review those facts de novo. Unless the court has further inquiry, then I will, I'm showing 5:20. I will reserve all of that 5:20 for rebuttal.
Got about a little over 5 minutes left. Okay.
Thank you.
May it please the Court. I'm Jennifer Somerville. I'm here on behalf of the appellee, SUNTRUST Bank. The decision of the trial court denying the motion to quash and denying the motion to strike should be affirmed because service of process was properly effectuated in this case on Mr. Hitchner. In accordance with Rule 1.070B, the trial court issued an order appointing an individual by the name of Scott Bancaro to serve process in this case.
Let me ask you this. Did the process server initial the summons, or I mean the papers, the original, the copy?
In his affidavit, he said that he did. This issue was not brought before the trial court
But
the affidavit of service.
That was never argued below, correct?
No, I mean,
it was
essentially.
the evidentiary hearing that was argued below.
Absolutely, and indeed, in the initial brief, the conclusion only asked for a reversal of that decision, not anything with respect to the substantive law as to whether the facts alleged in the motion to quash would justify quashing service.
In the bank, your client said there are no disputed facts. Correct?
Absolutely. I think that's clear from a review of the transcript that we said we will take your facts as you have stated them and alleged in the verified motion to quash, and we don't believe that that changes the result.
Right.
Rule 1.070 doesn't require the process server to identify himself, doesn't require him to tell the individual he's serving the basis of process, and it doesn't require him to give a copy of the order. And I think that the case law cited by everyone in this case about the strict construction to be given to rules and statutes related to process being strictly construed, and it weighs against his case. It's just not there. Because Rule 1.070 only required the initials and the affidavit of service tracks the language of the rule, there was just nothing for the court to hear. The arguments raised in the reply brief, we believe were waived. They weren't, the argument with respect to the Vidal case, not only was it waived because it was not included in the initial brief, it wasn't raised before the trial court. Essentially what he's asking is for you to reverse the decision of the trial court based on a theory that he never pled. He says he was entitled to an evidentiary hearing to develop facts in support of this argument that he never even raised. If I can, I would like to get to the substance without waiving the waiver argument. The statute doesn't even apply in this case, and we're talking about a fourth category of individual who's authorized to serve process. Under Rule 1.070B, the trial judge can appoint any person who is competent and disinterested. There's nothing in there about that person having to have an identification number, nothing like that. 48.031 requires that identification number to be on there. And there are provisions set forth that are analogous in the statutes relating to certified process servers who are maintained on the list, maintained by some chief judges of some circuits. And apparently, Volusia does not do that in this case. I
think in Vidal, wasn't it, there was a certified process server, but the person that actually served worked for that person. Is that what happened?
I'm sorry?
In Vidal, wasn't there a certified process server, on the list, and the person that actually served the process on the defendant in that case was somebody that worked for that certified person?
That's the Barabin versus Sussman case. Yeah.
Okay.
And that wasn't the case here, and that's certainly distinguishable from this case because the affidavit and the order match up, and they were all in the court file 5 months before the hearing on the motion to quash. And that's the primary case he uses in the motion to quash. But had he looked, those people were the same. But what I'm trying to argue is that 48031 regarding the identification number wouldn't even change the result if we were to get to that point, which I don't think we should, because I think it was clearly waived. It wouldn't change the result. What is required by the rule, and it's Rule 1.070E, requires that the date and hour of service shall be endorsed on the original process. And that's what happened here, and that's included in the affidavit. So really, everything that was required was in fact done. There was an additional argument raised in the reply brief, which you touched on briefly, saying that there had to be some type of disqualification on the part of the sheriff in order for the trial judge to be able to do that. And the case cited in the reply brief, and I believe that's the Exchange National Bank of Chicago. There's a case, I filed a supplemental authority yesterday, and I apologize for the delay. And while we were sitting here, if I can address this, I noticed that it was supposed to be faxed to Mr. Boswell yesterday afternoon, and apparently, inadvertently, my office sent it to a different attorney. So he didn't receive it until right before the hearing. But that case of Exchange National Bank of Chicago, where the court did say that the motion to appoint a special process server on 1.070 needs to allege the default or disqualification of the sheriff. The Bradley Fiduciary Corporation versus Citizens in Southern, which was the subject of the supplemental authority, says that that's not true. And that earlier case had been based on a rule of the 11th Circuit that had been rescinded. Essentially, this comes down to whether or not the process server in this case complied with Rule 1.070. That was the only argument preserved because the additional arguments were not raised. It would be unfair to the trial judge at this point to reverse them for something that was never presented. Because everything was done in accordance with 1.070, the decision of the trial court denying the motion to quash and denying the motion to strike and entering final judgment against Mr. Hitchner should be affirmed. Thank you.
Okay, thank you. I think you had 5 minutes left. This is incorrect, but I'll go ahead. Okay.
What appears to be suggested is that the appointment of an Elisor is not subject to 48.0315. And clearly, the legislature intended for that statute to apply to any process server despite how that process server is appointed. And so the fact that...
so under 1.070, the trial judge would have to give the Elisor some kind of number, ID number?
To be for the process server to be able to comply with the statute, yes.
Okay.
The statute is unequivocal, and under the Vidal case, the Fourth DCA has said that historically the argument has been that service of process is for notice only. In the Vidal case, the Fourth District said that's not true, that these requirements do not specifically have anything to do with notice, but they are the requirements of the legislature, and we have to follow them. And as do the process servers, and if the process server does not follow them, then the service of process is defective. I would take issue with the fact that we waived this argument below. When you look at the transcript and you look at the argument that we were seeking to make relative to the
It seems to me you would probably have that as your leading issue in your initial brief. That was the case. That was the burning issue.
When you review the transcript and the trial court judge asked for our basis of why we had moved to quash, And what we were stating within our complaint, it was not me who responded, but basically my opponent who responded, who said these issues are covered in paragraph 4 of the motion to quash. And when the court specifically asked me about our basis and what would be a basis, again on page 7 of the transcript and in lines 14 through 19, and asked me about the summons. I'm not afforded the opportunity to respond, and instead my opponent says it can be summarized in paragraph 4. So my argument, I'm not allowed to basically make my own argument here.
So you could have made it in your initial brief since it was such a burning issue, and you didn't.
But whether or not we raised that in our initial brief and then equally raised it within our reply brief lends credence to the fact that there were facts that were in dispute at the trial hearing that were unresolved, and that
What facts were those?
whether or not the process server included his initials on the...
I mean, that doesn't seem like that'd be a disputed fact. He either did or he didn't. I mean, it would be on the summons.
Correct. And that disputed fact was not resolved. But then whenever the bank came in and agreed to our facts, they agreed that the process server did not identify himself, and within the scope of that would be that he failed to identify himself as required by 48.031.
It doesn't say you have to identify yourself.
It says you have to write your initials. That's an identification.
Identify yourself.
Well,
a lot of bit different if I put BWJ and say, well, look, I'm Bruce Jacobus and I'm a process server. That seems to me there's a difference.
Well, the Vidal court attempted to try and reconcile why the legislature may have required these 4 items. And for instance, in Vidal, the issue was that the process server had failed to place the time that the person was served. And the 4th DCA, looking at that and trying to determine the intent of the legislature, suggested that that you could not affect service on Sunday, and there were time limitations. Although I don't believe this court has to get there, this court equally could come in and look at the Sussman case, which says that the appointment of the process server is not transferable. And so if the court had appointed Justice Swaya, whose initials are TDS, and the process server who served the process put BWJ, then the person who was being served would know that the person that served them was not the person that the court had appointed. So there is a rational basis for the legislature to have included that. Those are facts that we don't know. But we have alleged that the process server did not identify himself in any way, which would include, did not include his initials on the process, or on the documents that were served, and did not include an ID number. And that's what the statute requires. Those are facts that were in dispute that should have been resolved. But to the extent that the bank agreed with our facts, then that agreement would have been broad enough to say that 48.031 was not satisfied.
You've exhausted your time. Thank you.
Okay. I would ask you to either affirm or to, if this court does not believe that Vidal was correctly decided, to then acknowledge a conflict with Vidal in this case.
Okay. Thank you very much.
Thank you, if I may be excused.
Thank you.
Panel change.